Kunst der Versammlung.
El arte de la asamblea.
The art of assembly.
Welcome everybody to the 34th edition of The Art of Assembly. This podcast is based on a live event on 14th February 2026 at the Black Box Theatre in New Delhi. The Art of Assembly is a nomadic series of lectures and conversations on the potential of gatherings in art, activism and politics. In the last 5 years or so, we had quite a huge number of great speakers and covered a wide range of topics. So if you haven't followed, you might want to check out our website, which has become quite a substantial archive, collecting videos of our lectures, podcasts of all episodes, and a lot of extra material. My name is Florian Malzacher, and I'm the host of this series. I sincerely want to thank the Al-Kazi Theatre Archives and the Goethe Institute Max Müller-Bawan, New Delhi, for the initiative and making this episode possible. Today's edition focuses on people's tribunals between politics, activism and art. We want to take this opportunity to look closer into the concept of the so-called people's tribunals that go back to the Vietnam tribunals initiated by the mathematician, philosopher and human rights activist Bertrand Russell in 1966-67, with famous participants such as Jean-Paul Sartre, Simone de Beauvoir, James Baldwin and many others. Out of this first Russell Tribunal grew the Permanent People's Tribunal in Bologna, founded in 1979, but there were also many other adaptations and continuations worldwide. In many places, they still or even more play an important role today. Also in India, there have been several versions of people's tribunals, as well as other forms of collecting evidence and demanding justice where the official legal system is not functioning well enough or is too slow. So we will look at some of these examples, but also at the role of theatre. What is the performance of law in these tribunals, and what can theatre offer in addition or complementing such civic efforts? I am very honored about today's speakers. Varisha Farasat, advocate at the Supreme Court of India, argues that people's tribunals are often more effective than official commissions of inquiry in investigating right violations and formulating meaningful redress mechanisms. Human rights activist Harsh Manda reflects on the many people's tribunals he has been involved in, addressing incidents of mass religion violence and the contested terrain of citizenship in Assam. And theatre maker Zuleikha Chaudhary, who has, over the past decade, examined law as performance, exploring the role of theatricality within legal systems and the ways in which legal truth is produced through performative means. I will introduce each speaker a little bit more thoroughly. When they come, everybody speaks for like 15-20 minutes, and then we have time for a conversation. So, without further ado, I'd like to introduce Varisha Farasat. Varisha is an alumnus of the NLSIU Bangalore and Columbia Law School, where she was a Hankin Stoffel Fellow. She worked at the International Center for Transitional Justice in New York, where she advised governments, international tribunals, survivor networks, and civil society organizations on international criminal law, reparations, truth commissions, and transitional justice. She has been litigating in India, where she is at the forefront of legal defense in criminal trials and constitutional cases involving minorities, marginalized communities, intellectual and political dissidents, and journalists who have been wrongly booked under draconian national security and other laws. She has been widely published on human rights, freedom of speech and expression, international criminal law, international law, peace, and transitional justice. I'm very happy you agreed to be here, and the floor is yours.
Thank you very much to Florian, Zuleikha, Kanika, and the Goethe Institute for having me here. It's a privilege to be here. I hope I'm not the most boring speaker, as I am a lawyer. So my only endeavor will be to try and make it as interesting as possible. I have 15 minutes, so I'll quickly start by, so People's Tribunal, as Florian said, started with the Russell Tribunal in 1967, which investigated the crimes that had been committed by the US military in Vietnam. And that People's Tribunal was very powerful, and I think it had very, very prominent members from all over the world, and that's why it was a very influential body. And after the Russell Tribunal, like Florian again said, there were several adaptations of the Russell Tribunal at a global level and also at the local level. I want to speak to one of the most interesting adaptations of the People's Tribunal that happened in 2001 with the issue of the comfort women. I don't know how many of you are familiar with it, but the Japanese army in the Second World War committed many atrocities, including sexual abuse, rape, torture, etc., against women from different countries. And many of these people who committed these atrocities were in fact soldiers. And there was never any accountability for these crimes. And it was, of course, there was the Tokyo War Crimes Tribunal, which also was a formal body that did not look at these crimes. And so it was only in 2001, so you can see the gap, the huge gap between when these crimes were committed and when there was some kind of reckoning, a public reckoning of what had happened. And so it was the Comfort Women Tribunal that released its final report in The Hague in 2001, that for the first time looked at what had happened to these women, documented systematically their stories and their voices. So I wanted to start by the Comfort Women example, only to say that when official mechanisms don't work for many, many, many years or decades, then all we are left with are people's tribunals or the civil society mechanisms that tell us repeatedly that these were crimes that are unforgivable and we must not forget. And unless there is some kind of, I mean, I would not say accountability because I don't think there was any accountability, but at least some kind of an acknowledgement that these crimes had happened and these were terrible things that took place, and we as a global society can't move forward unless we acknowledge and integrate the voices of the victims. We cannot have a just society. So I wanted to start just to show the time gap. I don't want to talk too much about other global tribunals because I want to look at the Indian case. But I think the Russell Tribunal on Palestine also needs mention for the simple reason that that again had many influential members, including a South African human rights lawyer and someone who had been a part of the South African Truth and Reconciliation Commission, Yasmin Sukha. It started its work in 2009, held hearings in different cities like Barcelona, Cape Town, and eventually released a report on what was happening in Palestine. And I think that was a very, very important moment for people's tribunals, because I think apart from the international human rights organizations like Human Rights Watch, Amnesty International that were talking on the Palestine issue, there were no global forums that were actually addressing it. So I think it, it played a huge and a very important role in not only documenting some of the crimes that were happening, but also in raising awareness about these issues at a global level. So I think these global people's tribunals have played a very important role in keeping the issues alive, because we all have limited attention, in keeping the attention of the global community alive to these issues. So they've served a very, very important purpose even for that. Now, and I just want to say one other thing. In fact, I think that the precursor to these Truth and Reconciliation Commissions that we saw in South Africa, and of course later on in many other post-conflict transitional contexts, was in fact the People's Tribunal. Because I think People's Tribunals were the first place where victims' voices or people who had actually been targeted or faced abuse or faced torture or whose family members had been violated in one way or the other, participated in these proceedings. And I think in the beginning it was mentioned that how these voices, the voice of the voiceless was included for the very first time. And I think the truth commissions, of course, these were official inquiries of bodies because they came into being either as part of a peace agreement and so on, and had I think more of an official status than people's tribunals. I think the ideas are very much the same. The ideas of acknowledging past crimes, saying that we can't actually move on unless we examine the past and investigate what has happened, and including the voices of the victims. So that's just one parallel that I see, and I feel truth commissions in some ways, if I can say, were inspired by people's tribunals. I have limited time, so I'll quickly now come to the context of India. I think in India, we've had a very robust civil society movement for decades on so many different issues, whether it was civil and political rights or whether it is socio-economic rights. We've had a very, very robust civil society. And so it was only natural that we would take and adapt this version, this model of people's tribunals to our own context. And Harsh is also speaking after me, so I'm sure he'll talk about some more Indian people's tribunals. But there have been many. They have dealt with different sorts of issues, whether it's issues of environmental damage, climate change, whether it is about violation of tribal people's rights, whether it is the Assam, the National Register of Citizens issues, or about, generally, civil and political rights in the country. There have been varying themes around which these tribunals, people's tribunals, have been organized. And so there have been many, too many to speak about in such limited time. So I will confine myself to two specific tribunals, one on socio-economic rights and one on civil political rights, just to give you a flavor of what these have meant in the Indian context. The one tribunal, which was a recent tribunal, and was held in 2024 in Calcutta, was a people's tribunal on the role of the World Bank. And it's a very interesting tribunal because it was appraising 80 years of, because the World Bank, I think, finished 80 years in 2024. So it was appraising the role of the World Bank in the global south, and it looked at the context of India. And I want to read something specific from what it tried to do. I think it tried to do a few different things. So it wanted to analyze the direct fallout of the different World Bank projects in India. It also wanted to analyze how the World Bank projects had shaped the Indian economy, obviously to the disadvantage of the marginalized, etc. That was a recurring theme around all of the issues. Then the World Bank and the climate paradox, which is a very, very compelling theme, I think, in all countries. And also how World Bank money has supported authoritarian regimes or authoritarian ideas, and how it has negatively affected resistance and advocacy. So I thought all the themes, and I'll urge all of you to go back and read that report. I think it's a it's not a very long report. All of us are in this world of Instagram, Twitter, 140 words, and so on. But it's actually a fairly exhaustive report, but not a very long report. So I'll urge all of you to go back and read it. And it deals with so many different themes that were important, and And I think it came to the conclusion, and the conclusion is quite important, and I'll read it. It says that the bank does not only push false narratives, but also pioneers false solutions, violating human rights and undermining the resource rights of communities who depend on nature for their survival. So it really looked at what these projects, which are often said to be supporting these marginalized communities or tribal communities, was in fact doing to them. It was doing something that was quite the contrary of what the stated purpose of these projects was. So very compelling read on socioeconomic rights, very relevant. Please go back and read it. In our country, I feel we don't have any corporate journalism. No one is doing serious corporate journalism as to how the role of the big corporates or the big financial institutions is affecting the livelihood of the marginalized in various forms. And I think, so to that extent, it was a very, very useful contribution in that sphere. And quickly, I'll end with this, and then I'll speak more in the Q&A. The second one that I want to talk about, again, which is a very recent, contemporary topic and a disturbing topic, is about the National Register of Citizens in Assam. And all of you will be aware of the fact that Assam is a very, very politicized issue in India, where people have been saying that there has been a lot of Bengali migration, which is changing the demographic, etc. There has been a lot of communal hatred that has been spewed in various forums by very senior leaders of the ruling dispensation. And in that context, and I really want to talk about this particular tribunal for the simple reason that this People's Tribunal that was looking at how constitutional processes have been subverted in the entire NRC process in Assam had two retired Supreme Court judges, very, very well-known and well-regarded Supreme Court judges, Justice Madan Lokur and Justice Kurian Joseph, and a very well-regarded retired former Chief Justice of the Delhi High Court, Justice A.P. Shah. So, I mentioned their names, and very well-known social activists like Sayyida Hamid. And I mention their names because the People's Tribunals are also dependent on who the jury members are. The credibility of the jury members, when they are well regarded, where independent, people with integrity, it also gives weight to their findings. And so the reason I said there were three former judges is because when former judges who've been on the other side and have decided law come on this side, and then they hear all the testimonies and come up with the report, I think it's a very compelling report. And that report once again identified huge gaps in the NRC process, how it had undermined the very foundation of our Indian Constitution. And I'll give you just a couple of examples. I don't know how much time I have left, but I'll just, end by saying that it pointed to serious lapses in the NRC process, where you identify that this one is a citizen of India, and therefore their name will be put in the citizenship register. Everyone else will be deported back to Bangladesh. And the foreigners, People's Tribunals in Assam will then determine whether they are or they are not. So it pointed to serious lapses in that process, also using things like sealed covers to establish family tree, which means that, due process rights of those people who were being ousted as foreigners were completely compromised. Also, the very fact that the court undertook the process of ascertaining the NRC process itself, according to them, was problematic. So I think that I'll stop on this, except to say one more thing, and that is that people tribunals have also been an effective tool in acknowledging and documenting communal violence in India. We've always, and this actually brings me to my very, very last point, is that in India, we've seen many episodes of communal violence or communal pogrom, whatever we want to call it. And all of those episodes have been investigated by something called a commission of inquiry. So we know that whenever the government doesn't want to do anything, they form a commission of inquiry. That's the joke that goes around here. But I do think that even those official commissions of inquiry are useful and valuable because they document what has happened and to some extent try and integrate voices of people who were affected or their families suffered. And I think, so there have been several official commissions of inquiry, and although their recommendations are not binding, they can suggest things to the government, either to the parliament or the state legislature, which they are then supposed to do. But I think in that area as well, it's both official commissions of inquiry, but as well as people's tribunals that have played a very valuable role in documenting these crimes and giving the victims a voice. Thank you very much.
Thank you, Varisha, a lot for this input. I think there's already a lot to talk about later on. But before I will, I'm very happy to introduce Harsh Manda, human rights and peace worker, writer, columnist, researcher, and teacher. He is chairperson of the Center for Equity Studies devoted to the analysis and development of public policy and law for justice and rights of disadvantaged groups. To counter rising hate violence and lynching, he leads the national initiative called the Karwan-e-Mohabbat, or Caravan of Love, for atonement, solidarity, healing, conscience, and justice. He has a PhD from the Free University in Amsterdam and has published more than 25 books, amongst them Partitions of the Heart, Unmaking the Idea of India, Burning Pyres, Mass Graves, and a State That Failed Its People, India's COVID Tragedy, Looking Away, Inequality, Prejudice, and Indifference in New India, and Ash in the Belly, India's Unfinished Battle Against Hunger. Harsh was a special commissioner for the Supreme Court of India in the Right to Food case from 2005 to 2017, during which time he investigated starvation deaths and reviewed implementation and directed public policy reform for advancing the right to food and nutrition in several states in India. 2022, he was on the shortlist of people recommended for the Nobel Peace Prize, and he was awarded an honorary doctorate by the University in New York in 2024. I'm very happy that you're here, and the floor is yours.
Thank you. It's a pleasure to be here. Just picking up quickly from where Varisha left it. I think India's had a long tradition of people's tribunals, although we may not have called them people's tribunals till the Russell Tribunal. But the idea of people investigating the actions of the state, often with much greater credibility than official mechanisms of investigation. And the context of mass, what we in South Asia call mass communal violence, violence targeting India's religious minorities, Muslims mostly, and Christians, Sikhs on some occasions. I've spent a major part of my working life, one part of it has always been with survivors of mass violence. And as a civil servant, as a human rights worker, as a researcher, and now more and more as what I could best describe as a peace worker, when I ask myself, what is it that after suffering the consequences of hate violence, I mean, firstly, that hate violence, if I lose my home and my loved ones to an earthquake, it's one kind of loss. But if I lose my home and my loved ones to the hate of my neighbor and to the prejudice and politics of hate of my government, it's a very different kind of suffering. I call it wounds of the soul, and a lifetime is usually too little, too short in order to heal those wounds of the soul. And I, over the years I've understood that for healing even to be possible, the survivor of the violence needs at least 4 things. The first is acknowledgement that it happened. The second is remorse, that it's terrible that it happened. And there is a public sense of regret. The third is reparation. The duty of the state and society to ensure that at least in material terms a person is restored to a situation better than before the violence. And then of course justice. And the history of mass communal violence in India, but I think in probably many parts of the world, is that none of these 4 things are accomplished. Is this better? Am I? So, the history of mass communal violence, I think, has been that, especially where the state is complicit, is that the reverse happens. Instead of acknowledgement, there's a sort of dismissal. It's sort of instead of remorse, there's often actually a celebration that we accomplished this. Instead of reparation, people are pushed into economic boycott, to the margins, excluded, and justice is widely subverted. The enormous role of people's tribunals into incidents of mass violence cannot be, overstated, because they accomplish at least the first 2 parts necessary for healing. They accomplish acknowledgement. As Varisha said, people who are respected in society come together, listen to the victims' testimonies, and then conclude that this did happen, these crimes did occur. That's, I think, the first thing that these accomplished. And secondly, a sense of public remorse emerges from these tribunals. And I think, I'd like to underline first this role. And why I say, actually there's a tradition, almost every incident, I think every incident of mass communal violence, and I'm trying to put together with friends an archive of the major incidents of mass violence. And I find that the judicial commissions actually carry far less credibility than the people's tribunals that have been put together, and their reports are important for posterity. But I was reading, when we were investigating the first incident, India had terrible riots during India's partition. 1 million people slaughtered each other. 1 million people. But under, after Gandhiji's assassination, after Nehru's leadership, these fissures began to heal. And the first major, what we call communal riot, happened in a place called Jabalpur. And it was a classic case of, there were two big bidi manufacturers, magnates, Hindu and Muslim. And the boy from the Muslim household and the girl from the Hindu household fell in love, and all hell broke loose. The story that was published widely, and what officials reported, was that this was this was a violence perpetrated primarily by the Muslim community. And I'm told that Nehru, a group of senior citizens, political activists as well, Zuleikha, Kriplani, etc., got together and said, we will do our investigation. And they went to Jabalpur, and we talking to old people, they were telling us how this tribunal worked, or this People's Committee worked. They said there was so much hostility from the majority Hindu community because they didn't want the truth to come out. So they wouldn't even give them a hotel room. And there was something called the Indian Coffee House, which was a sort of Communist Party collective, and the members of this tribunal would actually sleep on the benches, and they collected the information, and that's how we got to know the real truth about the Jabalpur violence. And it is that tradition, I think, that has been carried on. But I'd like to give a few other this has been adapted in multiple ways, and in my own experience in the varied spaces, I'd like to give you a few more examples. One is the right to information movement. Very briefly, grassroots level corruption withholds from very poor working class people their wages and their dues. And for a long time, there was only a dependence that you'd give an application to the official who is usually complicit in the corruption itself, and there's nothing you can do about it. And a movement, the Right to Information movement, started with a very simple, and I'll tell it how I remember a village, a woman in Rajasthan, and she said, and she started off by saying, like, in a democracy, who is the ruler? And then she said, I'm the ruler. And then she said, who's the government? And she said, wo hamare muneem hai. I mean, muneem is like your clerk or sort of accountant, yeah. And then she said, if the ruler doesn't hold their accountant, to do the right thing, then the treasure gets looted. And who's responsible? She said, the king is, the ruler is responsible. So the people must, hamara paisa, hamara hisab. It's our money, it's our accounts. And from this movement started, and this idea, what they call Jan Sunwai, which is basically where people would gather in a village, and they would take out what are called the muster rolls. Muster rolls is the place where who has been, who's got worked on what date and got how many wages. That is read out publicly, and when people set up, oh, this one's name is there, but that person's dead 3 years ago, or I actually worked for 10 days and they've only written 3 days. And through that device of public hearings, again, a huge movement of people's control over their own resources from the state began, which was very significant. Florian talked about the right to, my role for about 12 years as a commissioner of the Supreme Court. There was a case that a group of us filed in the Supreme Court saying at that time every second child in India was malnourished. And the amount of grain that we had in government warehouses, if you put those bags of grain in a line, you could go from the earth to the moon and come back. And yet every second child was malnourished. And so we spoke about, in this petition, about recognizing the right to food as a fundamental right. And the court held, very importantly, it said that the right to life is a fundamental right. And it is interpreted widely as the right that the state cannot take away your life or liberty without due process. So it's kind of negative right, but they said no, it's also a positive right, the right to that which makes life with dignity possible, and therefore the right to food is a fundamental right. But until there is legislation, the Supreme Court said it needed to have a mechanism, and two of us were made commissioners on behalf of the Supreme Court. Many things there, but I wanted to talk about people's tribunals in the context of the most about starvation deaths. Now, what normally happens in starvation deaths, and I've seen it from the inside as well. A government gets shaken if you can say there has been starvation, and there's standard practice that if there's a complaint that there's starvation in this household, they throw in. Sorry, I'm really. They throw 5 kilos of grain into the house from a window. So when the investigators come, they say, no, there was grain, so how could there be starvation? And so on. And then they post-mortem, they'd cut open the belly and say, no, we found 3 pieces of grain, so there could be no starvation. Which was, in terms of public compassion and the dignity of the affected family. So we talked about, no, starvation means that over a period of time, you don't have access to sufficient healthy food, assured access to sufficient healthy food for an active, to lead an active and healthy life. And so we used to have hearings where neighbors would talk about the household and how it survived and so on. And we used to call it people's tribunals for verbal autopsies into starvation. And it built a very different kind of community of care and responsibility around these. Homelessness, again, it's interesting, again, as part of work I've done for many years. This business, again, of sitting together and talking about your life and what you accomplish. And I thought I'd talk about a few diverse examples just for us to have a flavor. So homeless life, you have a set of people who are unhoused. And there was so much that you would learn if it was done with respect and I think, I feel that what you need to cultivate, especially when the power hierarchy is very extreme. Middle class well-housed people are sitting and trying to understand the rights denials of very powerless, marginalized, homeless people. The conversations in these tribunals would teach us a great deal, and I'll give you a couple of examples. a woman stood up and said, the first homeless shelter for women we were able to set up. What has changed most in my life? And she said, after 20 years since I've been on the streets, for the first time when I close my eyes at night, I'm sure that no one is going to rape me until the morning. Now, as a man, I don't think I'll ever be able to actually fully empathize what it would mean. But even for the women, the middle-class women in the gathering, one act of sexual abuse, sexual harassment, you struggle with it, often for years. What would life look like to you if every night when you sleep, some man can come and rape you, and there's nothing you can do about it? That you wake up in the morning and there's no police station that is going to register your crime. And tomorrow night when you sleep, there's no place of safety you can go to where this is not going to happen to you again. And no NGO of middle-class people will come out in candlelight marches in your support. What would life look like to you? I'm just saying that this process of creating a space of listening with empathy. We talked about food charities. And, how do you get food when there is no food? So, the idea, we imagine that we have a lot of religious food charities in this city in Delhi. We learn from homeless people that actually there isn't a single Christian food charity, which was really shocking for me. And I've spoken to the Archbishop, I've said, please remedy this. But then they spoke about the food charity in Hindu temples. And they said something very interesting. They said that the trouble with the food charities in Hindu temples is that they're not really looking at us. They're not interested in what we need. They have some notion of their sort of sacred duty or emancipation. So they'll give you oily sweets on Tuesday afternoons. I don't want oily sweets on Tuesday afternoons. I want sort of balanced food served to me with dignity on a regular basis. But no one's even interested in me. They spoke about Sikh gurdwaras where the idea of the langar is a beautiful one, but where increasingly in Delhi, if you look really destitute, they don't let you in. And they spoke about the only charity that they spoke about, food charity that had meaning for them, they spoke about in places like Nizamuddin near the Dargah. You can actually buy tokens when you go in food. And so you give the token to a homeless person, and that homeless person can then enter the restaurant and sit with dignity and order the food he wants. So the point I'm trying to make here is that can we imagine creating people's tribunals where we listen? We listen without judgment. We listen with unconditional respect. Empathy, to me, is only laterally an act of feeling. It first has to be an act of imagination. And we built a world where, we see homeless people. You cannot live in a city in India except during maybe the lockdown, where you don't see homeless people every day of your lives. And we know so little about them. And we care even less. Can we imagine people's tribunals as places of empathy and caring? And, the last example of it, actually, I'll give from one of the starvation related gatherings, where Musahar women were talking, and they said, what is the most difficult lesson that we have to teach our children? And I said, what is it? and they said, it is the lesson of how to sleep hungry. And I began to think, I have a daughter whom I love a lot, of course, and I imagined what life would look like to me if I had to teach my daughter this lesson. That, I had to tell her that, I work really hard to ensure that you get food, but there will be several nights every month when I can't give you food. And what I can do only is to teach you how to cope with that and still be able to sleep. And so this is where I want to end. I think that for people who suffer the consequences of a hugely unequal, but even more importantly, uncaring social, political, economic order, can we imagine People's Tribunals as a place where we construct at least an island of empathetic, respectful listening? And can we remember in the end that People's Tribunals are a profound way of deepening democracy, because these are places where we performatively reclaim the sovereignty of people, of the people themselves. So thank you.
Thank you very much for this. And as the last speaker, I would like to introduce Zuleikha, who is a theater director, lighting designer, former lighting designer based in Delhi. Her ongoing research considers the structures and codes of performance, as well as the function and processes of the actor as reality in truth production. From 2015 onwards, she has been exploring the framework of law as performance, the role of performance in law, and the performativity of legal truth production. Her works has been shown at many festivals all over the world, and she is the director of Al-Kazi Theatre Archives at the Al-Kazi Foundation for the Arts in New Delhi, and currently a scholar at the Center for Race and Gender at the University of California, Berkeley. I am very happy that you're here and that we now will move into the realm of arts and see how this comes together. Thanks.
I'm interested in the connections between history, law, and theatre as different narrative strategies, all of which retain the tension between speculation and imagination, as well as truth-finding and reality-making. My earlier and ongoing trial projects, and I'll just say a sentence about each: Rehearsing the Witness, the Bhaval court case, which continues 2014 to 2018 and looks at citizenship as performative, and Landscape as Evidence, Artist as Witness 1, held at the Constitution Club in Delhi in 2017. Landscape as Evidence, Artist as Witness 2018, that was in Goa at the Serendipity Arts Festival. And the third version, or the third iteration, which is called In the Matter, Rights of Nature, in Chandigarh in 2023, look at ecological issues, the Ken Betwa River Linking Project in Delhi, the question of tourism in Goa, and the issue of stubble burning, air pollution, towards inserting rights of nature into Article 21 of the Constitution in Chandigarh in 2023, all have visual artists as witnesses and their artworks as evidence. These are staged hearings with real lawyers, retired judges, and different kinds of experts, photographers, historians, legal scholars, anthropologists, visual artists, and actors as central witnesses. The judgments in these hearings are not pre-known, and I'm happy to talk about the process when we speak a little later on. Historically, trials have been staged events. They employ dramaturgic elements and theatrical devices. They have their particular scenography, scripts and roles assigned to each actor. Trials also have an audience, the public, the media, and their critics. As events, they only complete themselves in the presence of this audience. Here, disputing stories are told. The defendant and the plaintiff each tell a story, and the narrative accepted as the real version is one based on the court's perception of the truth of past events, which is rooted in the organization and interpretation of evidence, an accumulation of documents, witness testimonies, and other texts and images, all of which form the legal archive or the official historical record. For me, both theater and law assert productions of truth and reality, the construction of narratives, a historical frame of reference, and the creation of alternative conditions for the future. What can theater uncover about the theatricality that is always present in courts and is integral to political life? Can theater help us arrive at different forms of justice and judgment that remain outside the reach of the courtroom? Theater is an art of enabling things to appear by speaking for them. Both the theatrical and forensic method make human behavior the object of inquiry. Both treat their subjects as evidence. Character in both contexts affirms the evidentiary principle. By the demonstration of a person's action, we come to know them. In theater, this often entails a slippage of positions as a performer stands in for a character. An audition is typically an introduction where an actor has to present a self-portrait as well as his technique and ability to become someone else. The representation is real and staged at the same time. The scenario is ambiguous. It produces an ambiguous, unreliable witness and an unreliable reality. Believability in the context of theater is credibility in the context of law, where the production of reality relies on the plausibility of a narrative and the assumption of a stable, consistent identity of the witness. The audition centralizes the actor as a witness, focusing on subjectivity and partiality and the entwinement of the fictional and the actual. Can doubt be considered not as contamination, but as a necessary friction between that which is scientifically corroborated, factual and objective, and a personal or narrative truth, or a social truth constructed through the debate and discussion of facts on a collective level, or a restorative truth which places established facts in context in an attempt to acknowledge individual experiences. If witnessing is always partial, is it possible to determine what truly happened from within the contradictions and different perspectives, not only between a state and its citizens, but between different communities, within different groups, and even within individual testimonies? I'm going to talk a little bit very briefly about my current project, ongoing project called Untitled Trilogy, which some of you may know about already, which comprises restaging the trial of Bahadur Shah Zafar, 1858, rereading the International People's Tribunal of Kashmir, 2006 to 2012, and Saeed Naqvi's 2022 play, The Muslim Vanishes. The project interrogates historical, contemporary, and legal enactments of the progressive erasure of the Muslim in India and Indian-occupied Kashmir through restaging the historical trial of Bahadur Shah Zafar, recounting investigations of the IPTK, and to speculate on the complete disappearance of the Indian Muslim in Naqvi's play. I'm going to talk just a little bit and show a little bit of a clip from restaging the trial of Bahadur Shah Zafar, which is part 1 of the trilogy, with lawyers Harish Mehla and Shahrukh Alam, restaging the trial of Bahadur Shah Zafar, unfolded as public rehearsals 3 to 6 here at Black Box Okhla from December 2023 to May 2024, towards a contemporary trial to be held further this year, I hope, arguing against sections of the Bharatiya Nyaya Sanhita or Indian Judicial Code 2023. In 1857, in a popular uprising, several regiments of the East India Company, the EIC, rebelled against the company and installed the aged Mughal poet king Bahadur Shah Zafar as their ruler. While the uprising still swirled in many parts of the country, Zafar was swiftly captured and subsequently put on trial at his own imperial palace, the Red Fort in Delhi. The trial paved the way for India to be officially placed directly under the British Crown a few months later. Denied proper legal counsel, Zafar was soon found guilty of heading an international Muslim conspiracy to wage war against the state and commit treason against the British government in India, and was exiled to Burma, now Myanmar. Zafar's trial was staged to portray a commitment to the ideas of rule of law and due process when neither were actually followed. Though the legitimacy of Zafar's trial has been heavily questioned and criticized, not least because the East India Company had been formally operating in India as vassals of the Mughal state, the trial's guilty verdict and the subsequent banishment of the old emperor ushered in a new sovereign in India and thus created a new constituent power, which ex post facto legitimized the trial itself. If we place the trial of the last Mughal emperor by the East India Company as the key event that helped establish the official colonial legal system in India, how can the deconstruction of this foundational event help us to, I quote in quotes, decolonize how law is structured, understood, and practiced in India today, and about who can access the courtroom, what constitutes evidence, and what justice may entail. I want to play a small clip from Public Rehearsal 6. This is actually about a 25-minute audition with Sudhanva Deshpande, who's an actor and an activist himself with Jannatya Manch, who was auditioning with me for the part of Bahadur Shah Zafar. This is an audition for the part of Bahadur Shah Zafar on the 21st and last day of his trial, using the translation from Hindustani of the written defense put in by him, the ex-king of Delhi. The court is assembled in the special hall of audience, Diwan-e-Khas, at the Red Fort Palace at Delhi at 11 o'clock in the morning of 9th March 1858. In this audition, I will be playing the part of Zuleikha Chaudhary, and the part of the actor will be performed by the auditioner.
Must Mustard was blooming on the barricades. Marigolds were dancing on the borders. The kernels of maize had found carnal desire in the alliance of bodies, full of red and green, yellow and cream, in orange and black. We were back. The protest brought back a full-blown smile on the faces that the state had stolen from us. We marched. We marched from Amritsar, Jalandhar, Patiala, Moga, Tarantaran. We came marching like the march of the forest in Macbeth. As Vernon Wood had marched to Dunsinane Hill, the paddy field marched to Raisina. It was an exchange of roses and marigolds on the borders. Red meant orange and green meant blue. Paddy fields danced with water cannons and bodies with batons. We came marching with banners and flags, with legs and lads, in pagri, in shalwar, in pajama and turra. We came marching on the rhythm of the gitta and the bhangra, on the rhythm of the nagara. We were determined to reach there. They tried to crush us. They tried to cut the blossoming flowers as they did with the Muslim protesters in Shaheen Bagh. We came prepared to celebrate Baisakhi and Lodi in their life. Covered in green and yellow, we marched as fields were marching. We marched as crops were marching. We marched as wheat was marching. We marched as soil and sweat were marching. Pulsating in our bodies, pulses came marching. Gram secured its nose and marched. With a torn belly, wheat joked to bajra. What else can they do to me? In the wee hours, we marched like butterflies. At night, we marched like fireflies. At noon, we marched with the sun. In the evening, we marched with the moon.
So, what was it like to be there that day?
Every pore of my body was open.
Why did you join the protest?
Because those who produce the food that I eat were marching in protest.
So, why do you think we can rely on your memory of that day?
Because it is the memory of the millions, not the minions.
So, do you think there is an art to protesting?
I don't romanticize these things.
So, your answer is?
Protest doesn't just stem from nowhere. It takes a lot of people to make it happen. They come together, they organize, they talk about things. You could say it's an art, but it's a lot of labor.
So, can I ask you what is your name?
My name is Sudhanva.
How old are you?
I'm 56 years old.
Where were you born?
In this city, New Delhi.
What is your religion?
I don't believe in God.
Would you consider yourself to be a good person?
On balance, yes.
Have you ever broken a law?
Oh, many times.
So can a good person break laws?
Of course. If the laws are bad, then a good person will break them.
Have you ever lied to anyone?
Yes.
What is your occupation?
I'm an actor, but currently I feel like I'm being looked at as a criminal.
It's an audition.
It feels like a trial.
So how would you describe your physical appearance? Just to say that the auditions, there is a script. As you saw, there was some parts of it Sudhanva was reading. So there's something for him there to read, but there are many questions in there. So we're both following a script as a baseline. But Sudhanva had never seen this the script except for the morning that he showed up. So just to say that it was not rehearsed. I consider that theatrical performance is not simply an output of Untitled Trilogy, but a method of investigation taking the form of public rehearsals. Rehearsing allows for a slowing down and an attending to, a making visible of that which would otherwise remain hidden backstage, allowing for the possibilities of connecting not only what is and what should be, but also what might be. I consider rehearsal a practice suspended between predetermined and experimental role-playing within the entanglements of system scheme and contingency randomness, not as a revision or further development of something fixed, but rather that it is necessary to start from the beginning again and again. Rehearsals as an experimental laboratory where not only are the elements pertaining to an artistic theatrical production put to a test, but also the formation of the subject matter happens exactly through this feedback system. Can the nexus of text, test, and rehearsal destabilize existing systems in favor of a provisional logic that breaks itself up at every moment? The rehearsal is never able to meet the demand of completeness or comprehensiveness. In rehearsing, one does not perform. Instead, one waits to perform, and while waiting, one produces actions and gestures while practicing moves. The rehearsal as a practice in becoming. And I wanted to talk about the rehearsal because I've been asked many times, and I think it's an important question for me to think about and also ask again, I guess to myself and the lawyers who choose to work with me, that why do they choose to work on these projects? And I think it is, from what I've understood from my conversations with them, it is because the projects allow for a rehearsal, for them to rehearse. And there are one question for them, which they are rehearsing, and I want to just say that, because I talked specifically with Shahrukh quite a lot about this, is that within the black letter of the law, can embodied and artistic practices, so by Shahrukh being part of these rehearsals, and the project itself, if we consider as a rehearsal, does it allow Shahrukh or Harish or Anand Grover, who's been a part of this project previously, or Aditya Sondhi, who's another lawyer who's been a part of some of the public rehearsals. Does it allow them to rehearse the web of cultural, historical, political relations as legitimate legal narratives? For me, these projects are actually thinking about, and through the actor particularly, what kind of knowledge can impact can theatre, in my case, generate that activism and theory alone cannot. Thank you.
Thank you very much for your talks, and thank you very much for your work. I think there was a lot of things to digest also, but maybe for the beginning, trying to bridge a little bit between these aspects of art and activism that we are also talking about here. In your talk, you mentioned it, or actually in the question to the actor, Zuleikha, you mentioned it, where you asked what role can art play in a protest, and I think the relationship between art and activism and theater maybe specifically is not necessarily an easy one. So because theater is, as you also said, Zuleikha, is something where everything is true but also fictional at the same moment, and the fictional part is something that with activism often produces some skepticism, I would say. So I've heard a couple of times in artistic projects that activists would say, like, but you have to make theater out of everything, and it is not meant as a compliment. And I remember a trial, Milo Raue, Swiss theater director, staged some trials, and one person in the audience said, yeah, for you it's theater, but for us it's our lives. So there is something, also a tension. There's, I mean, with all the relationships. So maybe Varisha and then Harsh, to bring you back into the conversation, what is your view on the role of art, or what is your view on trials like Zuleikha is staging? What can they produce, or maybe can they also be counterproductive in your view? I don't know.
I wanted to compliment Zuleikha. The dialogues are really good. And I think we as lawyers could learn something from it. If nothing else, how to make our arguments more interesting in court. So I think that art definitely does. To come back to the question, what you've said, in fact, everything in court is quite performative. As lawyers, like as arguing lawyers, because, you know, we are putting a case in front of a judge. And it's not theatrics, I won't say it's rehearsed or theatrics. But a lot of it is, you know, back and forth conversation between the judge and the lawyer. So, you know, like you are making your arguments, and then the judge asks you a question, and then you'll sometimes take that question, answer it. You'll try and use wit and humor, you know, sometimes when you're in a difficult situation in court, in difficult facts. You'll, of course, try to be as fair to the court as possible in putting your points forward, but I do think that a lot of what happens in court is also performative. Of course, we are much worse actors than the real actors, but so there is already that sort of, I think there's already that sort of link between the two. And I think what art can do is things we cannot say in court. Artists can say that. So I think it really has a very, very important role to play in terms of resistance, in terms of protest, in terms of, you know, this whole thing of, and why only courts, you know? There are things that can't be said in the Indian Parliament, for instance, criticizing the state. So I think what artists bring to this whole thing is what can't be said by us in courts or in parliaments can be very freely. And I mean, of course, it's debatable now what's happening in India, the sort of, you know, crushing of dissent. But you have that great tool of being able to say what we can't say in these official spaces. And I think that's really the value of it. Zuleikha can say, so many things and so much more eloquently and so much more interestingly than I can say in my court arguments, because very often you have to confine yourself to a particular structure or to black letter law or to the specific facts of the case. But as an artist, I think you have so much more space to take those same facts and to create something which is so much more valuable, which can show a pattern. Because, as lawyers, and I'll just stop, you are arguing one case. And so I'm talking about the particular facts of a case. But there is a pattern where many individual cases, where there have been human rights violations or whatever else we want to talk about. And artists can bring all of those different facts and show us the pattern that we need to know as a society, that these are not isolated incidents. So I think there's great value in artistic freedom and how you can actually amplify what's happening. I don't know if that's the question you asked, but...
Harsh, I'm interested in your view on this, but also the question, there's this famous phrase, the truth and nothing but the truth, which is obviously something which in theater is difficult, because even, in this piece, part we saw, it might be the truth, but actually we don't know. It's in the theater, and everything becomes a bit more ambiguous in a way. So I wonder, is it only a positive view on what the art can do when it deals with legal issues and moral issues and ethical issues?
For me, art can do many things, but probably the most important is storytelling. I think that, as I said earlier, empathy has to first be an act of imagination before it can be an act of feeling. So you pass a homeless man begging. If at all, you might hand some money, but is there curiosity? Who is this person? I wonder what his life would have been. I wonder what he's thinking now when he sees me. I wonder what his dreams are for his own life. I wonder what he thinks about the country, the world. Curiosity, respect, empathy. I think all of these are closely related to telling stories. And for me, that's a really important thing. And while Varisha was thinking, I was thinking of, I've been in court many times trying to raise issues. But there's one which was rather dramatic, and while it was going on, I was thinking it was like a one-act play. So briefly, I would hear horrifying stories about the detention centers in Assam. So these are places where you first reverse, very briefly, you reverse the burden of proof. So the state doesn't have to prove that I am not a citizen. I have to prove that I am a citizen on the basis of records that I don't think I could assemble, records. I don't even know the names of all my great-grandparents and who they were and where they were. And we also a partition family. So anyway, so once the state decides that you are illegal, they put you into detention centers. And these detention centers were jails within jails. And no non-official was allowed entry. And so 2017-18, the National Human Rights Commission, I don't know why they had this lapse of judgment. They briefly asked me to be their monitor, special monitor on the condition of minorities. And I agreed with the condition that my first mission will be to Assam into the detention centers. And there was a lot of panic, etc., but for some reason they wanted to hold on to me. And so they agreed. And I went into those detention centers, and I can't tell you, they're as close to hell as possible. So what happens is that so the man would be put into a men's jail, but in a jail at least you have some rights. You go out. So it's just this kind of space. Women, the matriarch is separated. Her children are outside. So I went into this space, a little larger than this auditorium. 170 women had not stepped out of that place for 6 years, 7 years. And they never could effectively because they don't have the documents. And after a little while, they felt that some strange guy has come, but he seems sympathetic. And because the language was there, what they did was they knelt down, and there's something called the Rudali, that is when the morning, sound of morning. So they all collectively, 170 of them started chanting their grief. It's something that I'll remember till my last day. And then I came out, I wrote a very strong report. The National Human Rights Commission panicked and they said, we can't send this report. The government will get angry. So I said, I didn't know the job of the Human Rights Commission was to make governments happy. But anyway, and I said, it's so important that if you don't, I will resign and I will make this report public. I did that. I thought there'd be national outrage. Nobody cared, except some UN rapporteurs. So I went to the Supreme Court. So I'm sorry, it's a long story, but so at the point, the judge was an Assamese gentleman, and he said, just 1,000 people in the detention centers. Why aren't there 50,000? And people told me on the ground that it created panic and fear because they said more people will go in. And I said, if my intervention has actually made life worse for them, my conscience would not accept it. So I told my lawyer, now the only thing we can do is you tell the judge that he's displayed bias and he should recuse himself from the petition. And my lawyer, Prashant Bhushan, very dear friend, he started laughing. He said, I have to appear before him tomorrow. I can't do this. I said, what can I do then? He said, you dismiss me as your lawyer and you say I will argue in person, which I did. And then I go in and I'm standing in front and the Chief Justice says, Mr. Harshmander wants to the recusal of the Chief Justice of India. I said, yes, sir. So he said, say what you have to say. And I prepared some notes. He said, no, you say. So I started off, I remember, with these words that I came to the highest court of this land seeking justice, but true justice is always tempered with compassion. And I found in your response a singular absence of compassion. And then this thing started between us, 45 minutes, which is what I would have enjoyed if it could have been written into a one-act play. But I tried to tell these stories. I tried to do, exactly what, in a sense, I was performing an art in the court and trying to stir his conscience through the stories I had to tell of what was happening. And anyway, in the end, he did something really absurd. He said, I thought he was going to say contempt and go to jail. He said, no question of me recusing myself. I recuse you from the petition. And there's nothing in the law. I was the only petitioner. And he said, no, you can't appear before me now. But as a result, he did pass orders ultimately, and people started coming out of the detention centers. I don't know, it's a long story, but I just felt I was performing, and I was actually performing art in making my arguments because I thought he was so lacking in compassion. I thought I could stir compassion through the telling of stories, which is art.
Thank you. Zuleikha, how would you react to so the idea that in the artistic space things can be said that cannot be said maybe in court, not at least this way, and the idea of storytelling, but also raising competition. Would you see this? Can you relate to these aspects, or what would you answer to these demands towards art?
In these staged hearings, which they're basically one-day events, it may have taken up to 2 years to research everything, get a petition made, etc., etc. But essentially, this is a one-day event. They are not rehearsed in the sense that we've all met one another. So the lawyer or the lawyers will have met the witnesses and spoken to them. They may have met one another, but nobody has rehearsed. There is a script, and that script is questions that will be asked, just so that we stay to time, because they're often up to 6 expert witnesses, which is then we're heading into 3 hours. The judges, retired judges, difficult to find, only come the day of the event, so they don't know what's to come. I send them the petition the night before. So I'm trying to set up, or I work very hard to set up things just as they are. We're not making up laws. We're trying to stick, and I think that's the question for me, is the necessity and the importance to stick with what there is. And then the insertion of something as the artist as witness and the artwork of evidence as evidence within this structure, and keeping to protocols and laws. Is there any possibility for lawyers, particularly, I would say, to negotiate and maneuver within what there is, to push what exists and where it exists, because I'm interested fundamentally in the question of a legal precedent, because I feel like this is also what law and theatre have in common, which is that something new gets produced, a vision of something else which didn't exist before suddenly appears. And that's where I find the relationship with theatre is. And so the events are set up to, the events are set up in a way to, as I guess, as a test, as a trial, of seeing what boundaries can be pushed and how, which is about language, which is about everybody's language. The first 2 times, the judgment, after we had the same judge twice, and we lost the case twice. And he said, so when I asked him, why are we losing? He said, actually, you're not, the way that you're framing your arguments and your position doesn't allow me to rethink anything. So it is, you have to find a way to present your case and the questions you're asking that push to a future. And I thought that was really very productive for me. I've also, which is what I ended in talking about, I think of these as rehearsals, really. So they're processes, and it's a rehearsal, and you go on repeating it again and again. And in the hope that you find, as with the rehearsal process, you find something new, something different, you find a breakthrough. And so I would say that I've moved from thinking, okay, the trial is important, the judgment is important, is this real or not? Because very often the judge gives us a written judgment, he'll read out the judgment and then he'll send it to us later. So I'm trying to stick very much to the protocols. But I've moved a little bit from that through the Untitled trilogy to thinking about this as larger processes, and also to think about who the process is for. It's not actually for, it is also, but I would say not actually for artists or actors. It's actually, mostly I've realized it's for lawyers. it offers them an opportunity to try and make some movement, I would say. And I do, so I don't have actually any sense of, I don't have a claim about the projects. Essentially, they are pretty self-reflexive in asking myself, in fact, via other artists, what can art do? Because the words like evidence, words like particularly evidence, they're meaty words that are used in art discourse. And these words actually have meaning in a very particular and singular way in the real world. Evidence is something when you want to put it as a proposition in, as the theme of an art show. But actually it means something very, very specific. And I'm curious about that usage of language within the arts. And I'm curious about, I am essentially curious about, so it's a question for me. The projects are in effect a question for me about what can theatre do? I don't know what the answer is.
I think when you're saying, okay, you have to frame it differently and thinking about procedures and so on, I'm thinking about one thing that in your work, but also in a way, people's tribunals, that they could be considered in some way as pre-enactments, which is a term from the art there of the idea that you not reenact something, but you imagine something that could be happening in the future, and you kind of train for that, you develop ideas and formulas for that. And on the other hand, I'm wondering that the system you refer to, Zuleikha, but also the people tribunals, so much stay within the realm of existing laws and thinking about laws. They kind of mirror certain procedures and so on. And we had in the series also Radha D'Souza, a British Indian lawyer, and she wrote a book, I think it's called What's Wrong with Rights, where she kind of like looks at that, or argues that something fundamentally is wrong from the beginning on as a colonial system and based on properties, etc. So I wonder, did you encounter your work? Are you or are you also working on completely trying to find different ways from the beginning on and not mirror the legal system or complement the legal system with the forms you do?
Yeah, it's a very interesting question, and I'll just, I think the strength of people's tribunals is the fact that they may mirror the laws, and I think Zuleikha is also pointing to that, that you're trying to stick, within whatever the statutes are. But I'm saying that to hold someone responsible in criminal law, in actual criminal colonial law, you need a very high threshold, which is a beyond reasonable doubt threshold, which is a very difficult threshold to prove, because when we are because I do trials regularly, you have extensive cross-examinations as part of that trial, and you have to, because the accused can be sent to jail for life, etc., and so there are very serious consequences, and therefore the level of evidence that is required to convict someone is very high in courts. And that's our colonial system. But I think the beautiful thing about people's tribunals is that that same level of evidence is not actually required. And therefore, just taking on record a victim's statement or testimony saying, look, I was wronged. Look, this happened to me. Look, someone was disappeared from my family. Someone was murdered or tortured. So many people were killed from my family in a communal violence. Someone was raped. So I think that the threshold of evidence is much less, and I think it's a good thing, because it's not like, and in a way it's good that, you can't convict anyone, etc. But what you are actually doing is, I won't say lowering the evidentiary standard, but what you are actually doing is you're trusting the voices of people who were actually violated. And I think that's a great thing that people's tribunals do, because very often, and I also deal with people who've suffered sexual violence. Rape cases are impossible to prove in court. They're absolutely impossible. Whenever someone comes to me, even today, and they'll say, "Oh, we want to file a young woman will come to me and ask me, I want to file a rape case." I try to dissuade her, because the criminal justice system is so long. It takes such a long time. And, there are many good things that have happened. There's more sensitivity with by the judges and so on. And, the way evidence is recorded has changed a lot. But I'm saying that the fundamental problem of this beyond reasonable doubt is a very, very high threshold. So I think people's tribunals, by the very fact that they kind of do away with that, it's like, I think it's a huge thing, because you have the second thing, I think, again, which I think the criminal justice system will never deliver, is on the point of command responsibility. That very often, it's not, what we call the trigger pullers, and I'm talking about communal violence or mass violence, where it's a systematic plan and policy of the government, where people who are actually civilian, who are heading the civilian government, are responsible for these abuses. But very often we never see them being brought to court. And the person who's committed that murder or that human rights violation is being brought to court. The very fact that we had the International Criminal Court established in the first place at an international level at The Hague was because there was a recognition in the global community that you were not prosecuting those who were the most responsible, and you were getting the small fry to be tried because they may have actually committed the murder, but it was part of a systematic plan and policy. So I think people's tribunals are not bound by the tyranny of the law in some ways, right? And you can have your own evidentiary standards, and I think those testimonies are equally, they are very moving. They also speak to our conscience, and they're very, very compelling. And I just want to say I just want to add one more thing here, is that in fact, I've been practicing for a very long time, and I've been an arguing counsel for a very long time, and I feel that our judges really, if you speak to their conscience, it really has an impact in court. I think in a genuine way, if you're speaking to their conscience and raising their issues, because they are also a part of our society. And sometimes, because there is so much hatred in the media, sometimes, there's so much fake news in the media, and your judge who's sitting out there, it's also the lawyer's responsibility, I feel, that we must inform them of these issues, not by stating wrong facts or anything, but we must speak to them as citizens of the society as well. Sometimes we think that they are just judges. Yes, they are judges, and they have power and authority, but I think they are also citizens just like us. And if we pitch our case in an important, not important, but in a genuine manner, I've seen judges really sort of give very good orders. So I do think that we can't absolve ourselves and say this is the system, this is the system. We are all part of the system, and how do we? So I think there's some lines I'm taking from there, Zuleikha, to use in court.
Thank you. Harsh, since you have to leave in a moment, so maybe if there's a question from you, we unfortunately already have to come to an end, but if there's a question from the audience, please, you can think while Harsh responds, you can think if you have a question.
Yeah. 2 or 3 very quick things that I think in this very important conversation. First is that I've realized that our criminal justice system is founded on the premise that the state will be on the side of the victim against the accused. So all our human rights thinking has been about how do we protect the accused from the bias of the state and its power against them. In the work that I've done across, I've realized how faulty that premise is. Because in almost every incident of targeted hate violence against people of religious communities, minorities, caste minorities, women, sexual minorities, and so on. The state is on the side of the accused against the victim. And we have no way of factoring. So the victim actually is not, legally, it's the public prosecutor who's presenting the evidence. He or she is the one who's doing the cross-examination. But the victim is actually sitting there and saying, you should have been asking this, we should have done this. So I think that the People's Tribunal is also a place where the victim becomes center. The People's Tribunal is actually on the side of the victim. Exactly. And I think that's really profoundly what works. And the use of theatre, I was just recalling one story with the homeless. We were trying to understand. I'd gone to the Supreme Court when people were dying, homeless people were dying, I think 2010, 11. And I said, at least shelters should be there. And we had a very good judge who actually said homeless shelters are part of the right to life. 2,000 shelters came up across the country because of that order, and so on. But the shelters were very, they're almost like the poor houses of Victorian England. I mean, where you're just stuffing living bodies at night and taking them out in the morning. And we're trying to, and so we did a tribunal which I wish judges were listening to. And we didn't do it. Somebody was working with theatre, and what they did was they'd create a story, and suddenly, you're wearing this gamcha scarf. He'd go and put it on somebody in the audience and say, "You're the person now," and that person would continue. And really interesting insights about their experience was possible in a People's Tribune. So that's the second thing. Last thing, and I'll have to go, and I'll explain why I have to go as well. The last thing I wanted to say, it does something for judges as well. Art, it can. And that is accepting doubt. Let me explain. Amartya Sen has written this lovely book called The Argumentative Indian, where basically he's saying that the Indian tradition, philosophical tradition, has many, of course, problems. Its acceptance of inequality and so on. But the one thing it has is the acceptance of doubt. So you have the Rig Veda, which in beautiful verse, like the book of Genesis, tells you how the universe was created. And you've told this beautiful story, and the last verse is, but who knows actually whether the universe was created this way? I don't know, you don't know, only God knows, actually maybe even he doesn't know. Something to this effect. It's actually a profound, the Abrahamic traditions are built on certainty. I think judges sit with this notion of certainty. And I think art has the capacity to recognize that my certainty is fallible. And so along with storytelling, I think it is the fallibility of your judgment that art can promote. And why I have to go, just an interesting story. It's Valentine's Day. Yeah, I'm not taking my wife out or somebody else out for lunch. That would be a good enough reason. There's an organization called Dhanak, which actually works with couples who have married outside their religion and outside their caste and suffer a lot of hate and violence. They celebrate their annual day on 14th February. I'd agreed to be there at 2 o'clock and meet some of these couples. So that's the only reason I'm rudely leaving.
Thank you very much for joining. Maybe we just take a moment to finish it, not to stop so abruptly. And we'll continue a moment without you then, which is a shame, of course. But thanks so much for coming and for all your work. Thanks.
Thank you.
So I guess we also slowly come to an end, but since I offered the opportunity to ask a question or give some comments, please feel free. to do so if you want.
It's really the fine line of the art of theatre, the art of art, is that in my own personal experience, I would say very often theatre and art just simply become therapeutic. And I have done my performance in front of the art, or the art has encouraged me to do my performance of conscience, and that's it. So there's a very fine line which would then impel the audience or whoever is being addressed through the art to move forward rather than simply, be assuaged by a performative act of conscience.
I guess that goes towards you. Zuleikha, you want to respond?
I guess it's a question of, I think for me, who's in the audience that day. Because as I said, these are one-day events. The capacity of it holds a capacity of, I would say, maximum 200 people. I believe that thinking about the audience and who that is equally a part of making the work. So a lot of the audience has been activists, lawyers, those whom we've worked with, those who've come because their colleagues are there. Of course, with the landscape as witness, there are artists as well because they are the witnesses. And what transpires is exactly a legal proceeding with two lawyers arguing. One is always, since these are against the state, one is a lawyer representing the state, the other, and I'm the petitioner, so a lawyer representing me. And with the Khoj projects, it's Khoj and myself. And for me, it's important that both lawyers make compelling arguments. I work hard to get that going because I feel that that is what is of interest, and also that is at the center of theatre work. Conflict, which Florian talked about yesterday in Kochi, is that there's a conflict. And then there is a debate because you have two sides arguing. And what transpires is you see a procedure and a protocol being played out. You begin to understand whether you agree with it or not, why the judge has ruled the way, because he provides, or they provide reasons, their reasoning as well. So actually, I think what you're seeing is a procedure and something unfold and a system unfold in front of you. And I'm not at all biased against, I'm not biased in the favor of the judge ruling for me, which is, so I don't know how it will end. Nobody knows what the judgment will be. And I think I'm curious about that. I'm always curious about who takes away what, because depending on who you are, if you are a lawyer, you will take something, take away something. If you're if you're an actor or you're an artist, you'll take away something else. But I think the process is interesting for me because I am working with two lawyers. I mean, my instruction to the lawyer is I want to hear a legal argument so that I want to hear that argument, particularly from the state, that is also quite convincing for me. That's the positionality of what I would want out of the project. I've kind of answered it in a roundabout way.
Thank you. I think maybe if there's no urgent questions, since we are already here for 2 hours, there's one, then we take this one.
This has been lovely to hear, and I also, as Zuleikha ma'am knows, I work on theatre and law, and I tried to do this in law classrooms, to take theatre and law as a course to law universities, and then train these young lawyers through theatre history, make them enact certain theatre scripts, especially which challenge their idea of how official legal training is done in universities. So it was lovely for me to see final year law students to perform Manto on stage, and they wrote a script in which they said that we do not accept this partition, but they are going to be practicing law. And the idea for me as a theatre practitioner also is that they are going to enter a law courtroom tomorrow, and they are going to push the envelope of the law and how we imagine the law so far. But given that, from this discussion, I have some questions also emerging from the practice, that when we say that we are trying to open up the rigid evidentiary rules that are there and trying to bring in people's voices which are not otherwise heard because of there is a rule of law that one needs to adhere to within the legal system, within the rigidity and of the procedures. The moment we go there, you realize already that the state is not following that rigidity. So the evidence, it's already violated. It's not like the activists or the victim is when you're on the side of the victim is when you open the official definitions. The definitions are first being violated, I feel, from the official side. So that's just something that I have been thinking about.
Yeah. No, you're absolutely right, because I think the point is that, for instance, even our criminal procedure code, when we look at it, it is based on the premise that the police will conduct a fair investigation, right? So like the Indian criminal procedure code, or the latest, what we call the BNSS. So there is an element, and it's of course all come from colonial rule, etc. But it's like the state can do no wrong. It comes from that. So the investigating agencies or the police that represent the state, it comes from that particular. So the laws are made according to that the police is doing the right thing. Now, as a defense lawyer, I see day in and day out that the police is not doing the right thing at all. In fact, it is targeting the wrong people very often. And the investigating agencies are crushing voices of dissent, of artists, of lawyers, of journalists, of people who don't agree with the state. But the presumption in court is that the charge sheet, because the police has filed it, it's a correct recitation of facts. So I think that's where the problem is, because our entire system is based on the fairness of the agencies, which we now know that is not happening. So therefore, I think, but then I think the good thing about the judicial system is very often we do see that while initially those narratives or those charge sheets filed by the police are taken seriously, slowly as evidence is being led, those are being demolished in court. And that's exactly why the judicial system is there. But that's what I'm saying, that the entire criminal justice system, everything is based on fairness of the state instruments, because it's an instrumentality of the state. So, I mean, I think what you are saying is correct. I broadly agree with you. And I think people's tribunals are not constrained by those things. It's, in some ways, it's also where the underdog can go and say whatever they want to. And it'll be believed immediately without any proof.
Then do we consider Khap Panchayats as people's tribunals? Because then, it becomes confusing for me, because the moment you also take away the protection of the state, especially when it comes to a deeply patriarchal society, immediately, you have these elders taking over who are your traditional elders.
No, so I do think that's not what we mean at all. It's in fact, so it is a level of inquiry, and there is rigor in it. there is documentation, there's recording of evidence, there is a process that is followed. So it's not, and some people will say, Khap Panchayat is, I think, an extreme thing, and I think people's tribunals can definitely not be compared to it. But I'm saying, let's say, people sometimes use these terms like kangaroo courts. Are these kangaroo courts? That's the sort of disparaging term that's very often used. No, they are not, for the simple reason that if you look at people's tribunals starting from the Russell Tribunal, there was a very rigorous process followed. The people who were associated with it also brought law, justice. They had experience in that. There were people who were very influential voices in the society, people who were part of the jury, who brought credibility to the entire process. So I do think that it cannot, I think Khap Panchayat, is an extreme thing. I think it cannot be called that. And the credibility of it also cannot be questioned for the simple reason that, when you have a criminal trial, someone can be sent to prison for it. And so you're taking away their liberty. It's a very serious thing to take someone's liberty. People's tribunals are not doing that. But what they are doing is that they are raising, so in some ways, the end goal is a little different. What it is doing is, it is A, raising awareness about the issue. B, it is giving dignity to the victims who are then coming and putting their voices forward. And also producing documentation that can be lost at that time and can be used later, for any legal process. So I think they also can be feeding mechanisms for a more formal legal process, etc. So I think because of the fact that they are not doing what a criminal court is doing, I think these procedures can be slightly relaxed for them.
I'm just going to quickly make this comment because you said something about taking theatre to the law students. We have done a large project at Goethe Institute with Zuban, where we have looked at sexual violence and impunity. And they had produced books on sexual violence and impunity and taken cases from various parts of India, and they produced them in books, something that probably you can look at. And we had taken those cases along with, we had done a large project where we kind of open call, got theatre makers to come and work with the material and produce theatre, which was then taken to the first level of people who kind of encounter these cases, like your police people, doctors, lawyers, and it was used as a way to sensitize them towards the way they need to handle a victim, and not just from the point of view of only the law, but also looking at how law has changed over the years. Yeah, because the understanding of law and the way one practices it has also changed. So I think that material is still there. Those theatre, those plays are still there. And we are, some of them are still alive and they're still moving in various parts of India. So something maybe we can discuss later. I think there was another question. Yeah.
Thank you for this really nice, really amazing and awakening kind of conversation. My question is, so because we're talking about people's tribunals and then the performance of law and theatre, so there is a parallel to, or at least you draw, Zuleikha, the parallel to, cross-examination and audition. And I'm just wondering, like, formally, what would it be, what would be the form, meaning in people's tribunals? Also, because, people's tribunals made up of the public are also full of, publics are full of also performers. And in the technical term of the word, in how we all perform and so on. And so, there is this kind of a form to the cross-examination and the questions and answers and audition, and there is and so when you the kind of overlap of law and the kind of, how do you say, the structure of the law is clear. But in people's tribunals, I'm sure also, maybe, I don't know fully, but like how do you imagine, and how do you, Florian, and also Arisha, maybe, how is it that this overlap kind of exists, or?
I don't know how to answer that, but I think different people's tribunals have taken different forms. But I think, and I think one interesting thing, and I think I mentioned before, is that we are looking at people's tribunals, but truth and reconciliation commissions, actually, especially the South African one, I definitely think was inspired by people's tribunals in some way or the other. And that again, in fact, the South African Truth and Reconciliation Commission is a great example of performative justice and art. Because there, the victims would come and they would talk about, in their own languages about what had happened to them if someone had been disappeared from their family. And there was a lot of engagement with the commissioners who were the Truth Commission, who were heading the Truth Commission. And that is a great example, I feel. I'm veering away a little bit from people's tribunals, but saying it's a little bit similar, except for one is official, one is not. Is the Truth Commissions, where victims come and their testimonies are recorded, is actually a space where I think art, theater, justice, and victim testimonies, they sort of come together in a very beautiful but a very organic way, where victims are coming, and these are not people who are used to your formal court systems, and they are not even in a formal court system. So I think the other beautiful thing about people's tribunals is that you feel enabled to share your story. Whereas if I know court settings are very formal, because the victim then has to come in the cross-examination box, a witness box. And there I think you automatically feel constrained. Whereas if I was a victim, I was a survivor of any kind, I could come to these places and I think speak very freely, because I think it would be far less intimidating than a formal courtroom structure.
One thing that comes to my mind also there is like what you, Zuleikha, already mentioned. Like, of course, it's like, is there another position? So a cross-exam would be in a way not fit well the concept you're describing. And also Harsh was talking about the listening with respect. Cross-examining is not exactly. It's about something else. It's about finding a truth, and there is a certain moment of distrust in it, obviously, because you think something needs to be found out. And I think that's maybe also the let's say, the one thing in the people's tribunals that is not also relating to the legal system, it's one-sided in a way, because it assumes there's already the other side is in power and is predominant and is the mainstream, so it needs to present another side, and that makes it also, if you isolate the people's tribunals, maybe a little bit awkward, because you could say it's also like like a Stalinist tribunal, because it's one-sided. So it only functions because it's in a system of other opinions and gives voice to something else. I think that's maybe the point where the cross-examination also is like counterintuitive to the idea of the tribunal, if it is not in questioning the arguments of the state, for example, or the accused one.
I do have a question, and it's more of a question to you. So I'm always a bit suspicious of affect, and I think it comes from being in the theater, where affect can be produced. Rehearsals are towards that, and it's very much towards a believability. Because in the theater, you are looking for the truth, and an actor is working towards that truth. So it feels real. And so the question of affect, and I find the question of affect also suspicious, because it is on the basis, there are different kinds. When affect is deployed, which it is very much by the right in a very particular way. And I'm curious always, I mean, what was interesting to work with law and the idea of the witness was, so how does one gauge affect in a court of law?
Again, a very difficult question. I think there is no answer to it. But just to say, you may have heard this term that we say, oh, the witness has been tutored. Very often.
Yes, I have a project called Rehearsing the Witness.
Correct. So the witness has been tutored. And very often you'll hear that. And what it effectively means is that whichever side the witness is, whether you're coming from this side or that side, I will give in my testimony and the other side has the right to cross-examine me. So before I'm cross-examined, my own lawyer will sit with me and will actually prepare me to say, okay, if I'm asked this question, and it's a speculative exercise because you can only guess what the other side's lawyer will be asking you. So in some ways, you have to train your witness, and then you tell him, that if the answer is not in your favor, just say, I do not remember. So, things like that. So, of course, there is effect in it. There is, I think there is, and the other thing is, which is very interesting, and again, I don't think I'm answering your question, but before a witness takes the stand, they have to take an oath, which is like, I will state truth and nothing but the truth, and let God be my witness, and whatever, there are various forms of it here. You say, you'll swear by the Gita and so on. Whatever is your moral compass, you're made to swear by that. And I think, again, all of this is all in some ways theatrical, and in some ways affected, because we know that routinely witnesses lie in the witness stand, and so very often, I think that it is, they also know that they are performing. Very often they are tutored, and so I think that there is no great pressure on you to be completely truthful in your narrations. I think you're released of that burden.
Doubt as something productive is what I'm interested in. I feel I have a very healthy suspicion of affect, one way or the other, because of its deployment and because of its tremendous power. And so the trial format for me is, or I thought as I started in the beginning, that this was actually much more aligned to how I felt before. Of course, I understood that, that law is one thing, justice is quite another thing.
Yes.
Well, thanks so much for this. This was a very inspiring session. I learned a lot, and thanks so much for your talks and joining. Thanks so much for coming and listening, and have a nice day. Have a nice Valentine's Day.